Welcome. This presentation is available for MCLE self-study credit. If you would like to receive credit, you must take 3 actions. First, click Show More text below on our YouTube page. The text will expand and show a link to download the handout materials. Once you finish watching this presentation, please click the quiz link to receive self-study credit. Once the quiz is successfully completed, you will receive a certificate via email within 72 hours. We hope you enjoy the presentation. Thank you.
Thank you for joining us today, and I will introduce our moderator, Steve Sepassi. With over 25 years of experience as a skilled litigator, Steve M. Sepassi, Esquire, is a highly accomplished professional in handling a wide range of legal matters, including personal injury, school liability, real estate, landlord-tenant, commercial, and insurance. Known for his unwavering tenacity and civility, he constantly demonstrates a fair and respectful approach to mediating and resolving disputes, reflecting his successful tenure in private practice. Steve, thank you for being here.
Thank you, Anna. And thank you, everybody, for being here during your lunch hour, I hope. I have the pleasure of having two amazing professionals here with me. Let me just start out with introducing first Amanda. Amanda Moghaddam is a former legal malpractice litigator, formerly with Nemesek & Cole, a certified specialist in legal malpractice law by the State Bar of California Board of Legal Specialization, and a claims attorney now at Lawyers Mutual insurance company, where she oversees claims and assists members with claim avoidance and best practices. She's the current president of the San Fernando Valley Bar Association, for which I'm very happy to be associated with, and the vice president of the Valley Community Legal Foundation. Amanda, thank you so much for being here.
Thanks for the introduction, Steve.
Absolutely. I also have the distinct pleasure of having Greg Rizio with us. Greg of Rizio Lipinsky law firm in Santa Ana is a past president of Consumer Attorneys of California, a huge task. We were just talking about that before we all started, and also a past president of Calabodo. In addition to handling high-stakes personal injury cases as a trial attorney, he teaches trial practice classes at Western State College of Law these days. Is that correct, Greg?
That is correct, Steve.
Okay, thank you. In 2024, he successfully argued the case of Downey versus City of Riverside before the California Supreme Court, which expanded the rights of recovery for bystanders, which were created by the case of Dillon versus Legg, and now much more expanded by the case of Downey versus City of Riverside. Thank you, Greg, for being here. I appreciate it.
Thank you. And let me just say what an honor it is to be on with you and Steve, Steve and Amanda. It's just so refreshing having met with you guys this week to talk about it. You guys are amazing.
I appreciate it. Thank you so much. So the reason we're here is to talk about civility. And we know that civility has been getting a lot of coverage recently, starting with the State Bar creating a task force on civility and various rules of court that have come around. In fact, the State Bar has an MCLE requirement for 1 hour of civility starting with the 2025 reporting year, which is interesting. And also the Rule of Court 9.7, which modified the oath of office for attorneys to include that the attorney will be striving to conduct him or herself at all times with dignity, courtesy, and integrity. And as I said, plus other local rules that have come around about civility. I guess my question is, why is it that all of a sudden civility is getting so much attention? What's missing, or what's the point of this?
Amanda, you want to start?
Yeah, so I think that, the courts and the State Bar have started to really dig into this idea of how much incivility costs the court systems, the litigants, the participants, the witnesses. And so it's getting a lot more attention as we try to focus on access to justice initiatives. You kind of have to look at incivility. Sorry. You have to look at whether practitioners are acting civilly with one another, or are we creating more work for the courts for ourselves and, time entries for our clients. And so I think that it's part of the overall consensus that as we make the practice of law more efficient, more balanced, a lot of us are focused on work-life balance these days too. We have a lot of MCLEs regarding our mental health and how important that is. And I think civility actually, it kind of fits in every potential basket of the practice of law and our way to improve it. And so I think that that's a big part of it.
Okay.
I would add that I think there's two things, right? I recently spoke on a panel with the California Judges Association, and incivility is kind of the way people see the courts nowadays, right? Politically, there's a huge distrust of courts. Judges are being attacked. And I think when we kind of buy into that, we don't want anyone to think that that's really the way the courts are. We are a noble and honorable profession. And I think that, the more that politically we become more polarized, we want to make sure the court doesn't have that view. I think the second thing I would say, Steve and Amanda, is, coming out of COVID, we were talking about remote appearances. Now there's remote depositions, and you really don't ever sort of see your opposing counsel face to face. And it's so much easier to be, non-civil to somebody when it's a Zoom or when you're emailing. And it's much harder when you have to sit in a hallway outside of the CMC of the courtroom and have to, look that person in the face and deal with the way that you were kind of a jerk before, right? I mean, now I got to sit there and see them. It's a little harder. So I think the further we get away from in person, while we all love that, I think it also kind of breeds a little more incivility.
I get that. Thank you. That reminds me of something. When you said you have to sit, outside the courthouse or the courtroom and, be in the hallway. Many years ago, it was actually a federal court, and federal judges, as you know, wield a different kind of power. And I had a jury trial in the federal court, and we were about to close the case and hand it over to the jury, and we were not completely done with the jury instructions. And the judge was so mad at us. She locked the door on us that night and made us stay in the courtroom without food or anything to come up with the jury instructions so that we would work with each other. The opposing counsel and I would work with each other and come up with the jury instructions. It was very interesting and difficult, but I guess it accomplished the task. So I hear what you're saying. It's this whole point of not having personal interactions has made a difference. That's for sure. And maybe that's part of why this whole civility angle is getting a lot of attention from the state bar and the courts.
Well, along with that, Stephen, Amanda, I mean, think about it. We are in a profession where, everyone thinks we're supposed to fight and zealously and beat up people. Right. And, I'm doing my job if I'm a jerk. And it's really not the way it's supposed to be. But I think a lot of people feel that way.
Right. So that was another thing I was going to bring up. And that is, you brought up the idea of zealous advocacy. So how do you distinguish between this idea of zealous advocacy and not being civil or having civility in your practice, especially when you combine that with the idea that a lot of clients these days are looking at their attorneys as the fighter, as the gladiator or the bulldog. I hired you to go and fight and do this for me, and why are you being so kind to the other side? Are you my attorney or their attorney? All of these conversations that come up. So I don't know what your take is on that, but Amanda, maybe you should tell us, or you could tell us something about that.
Sure. So this is there's a lot to unpack there sort of with your question. And because I'm an ethics attorney, one of the first things it triggers in my mind is how important that client intake process is and how important it is to set expectations from the outset. When you have a client coming in and saying, I hired you because I want you to be a bulldog. Well, what does that mean? Let's talk to the client about what being a bulldog means, because if you're extremely aggressive in a case, we all know that that's going to increase the attorney's fees, the costs and everything, and the nature of the litigation. So we have to set real expectations for the client from the beginning. And we've got this is a important possible upcoming rule change where they're trying to change one of the comments to Rule 1.2.1. The comment would add clarity that the lawyer has authority to conduct themselves with civility, even if their client directs otherwise, so long as the lawyer does not prejudice the rights of their client.
Right.
So I put this sort of, I want you to be a bulldog in the same category as, the attorney makes the decisions really about the discovery deadline extensions and these other things that we need to engage in our day-to-day practice of law, right? Those really shouldn't be client decisions. And if the client is trying to influence the decision, I think it's important to sit with the client and to set those expectations that my job is to advocate for you, but I also operate in this system, right? And I have a reputation as well where I cannot be a jerk with my opposing counsel, because at the end of the day, you're going to need something from him too, right? And a little bit of give goes a long way. And so I think a lot of this comes down to the initial client intake and the setting of expectations. And I know Greg has some great feedback on this. When we were preparing for this, I just loved his answers. If he had called me on the Lawyers Mutual hotline, I would have told him he was a model insured for how he approaches other lawyers and just essentially what his philosophy is. So I'm going to turn it over to Greg.
So what I would say, and I agree 100%, Amanda, with what you said. Maybe that's why you like my answer so much, because you're 100% on, right, which is, a lot of when you're dealing with clients is, giving them their time, giving them, their love, giving them an understanding of what they're going to face. Yeah. And, when a client comes in at the very beginning, I have a heart to heart with them. I probably spend over an hour to an hour and a half with them at the very first consultation. I tell them what to expect. I tell them how to expect and, what defenses will be, what's going on from the defense. But I also emphasize to them, look, you're going to see me get along with the opposing counsel. And the way that I describe that with them is, it's like, look, I was raised playing sports. My whole life was we practice, we go to a game and, we fight really hard, within the bounds of, I was a soccer player, of the field or the pitch. And then afterwards, we're shaking hands, we're hugging each other. The pros, they exchange jerseys. And we're a noble profession. We're not much different than that, right? I mean, the reality is, I was a zealous soccer player, right? I wanted to win. I wanted to win hard, and I worked as hard as I could to do it. And I did everything I could to win that game within the rules. But at the end of it, we're all athletes, and here we're all lawyers. We have to get along. We have to be able to move forward. I also tell my clients that I get a lot more, better results for them if opposing counsel likes me, right? I mean, the reality as a plaintiff's lawyer is my job is to get them the top dollar that I can. And, Amanda's right. I'm going to have to ask for things from them. But at the end of the day, if an attorney likes me on the other side, they want to settle with me. I've had a lot of lawyers tell me from defense, like, I'd really kind of like, I wouldn't want to try a case against you because I like you so much and I wonder what a jury's going to think, right? And then ultimately, I want that attorney to call that adjuster and say, look, don't mess with this guy. He's professional. He's good. He knows his rules. And they're going to pitch and advocate to pay my client a little more than the jerk, right? We've all faced the jerk. It's like, there's no way I'm going to dig in and you're going to trial with me. I don't really have that. I mean, I will try cases. I don't have an issue with that. But if I can get my client out for a fair number and the opposing counsel is the one over there pitching to the adjuster, pay them, why wouldn't I do that?
Right. Yeah. And there's a lot of truth in that, right? I sort of sit in that carrier position now, and I can absolutely say the best settlements are achieved when the panel appointed defense lawyer and opposing counsel have a good relationship, right? And we're able to have realistic discussions as to the case's value, typically from the outset, by virtue of that relationship, right? And I think a lot of plaintiffs' lawyers will tell you that getting in there early to discuss resolution when you have the case that you have, present it to the defense counsel, present it to the adjuster, the claims professional right off the bat, show them the goods and explain to them why your case is the best case it can be, right? And that level of professionalism up front is always appreciated.
Most times when I'm mediating a case, Amanda, I go in and I do a PowerPoint and I meet with the other side if they want to see it. And I say, look, I'm not saying I'm going to win. I don't know. I mean, being a voter lawyer, I've tried a lot of cases, right? And I haven't won them all. So, your attorney's really good. And I'm worried that your attorney's really good. Again, I'm, helping the attorney like me more. I'm also being honest because any case could lose. But the reality is, this is why I feel good about my case. I mean, you could beat me, but this is why I feel good about my case. And even adopting what you're telling me, I still think I'm going to win for the following reasons. But it's just in that tone, right? It's just very non-aggressive, very pleasant. I just think that's the way to practice.
Mm-hmm. Mm-hmm.
Well, I think that's the idea of dignity and courtesy.
Right.
But I also think that. And maybe I should ask you guys, one of the things that you brought up, Greg, was this idea, and I think maybe Amanda mentioned it too. It's just the old adage of you can catch more flies with honey than you would with vinegar. And why not just, keep that as a, as your way of doing things as an attorney and just be that way. And I think one of the things that Greg mentioned when we were, again, preparing for this was this idea that the whole concept of civility really starts at the office with office staff and opposing counsel, the court, the client. It's an over-encompassing thing, and I think that's what the rules and the guidelines are trying to accomplish, is to create this, as you say, Greg, this put this noble profession back on track and get away from this hostility and bulldog type of behavior that's become a little more prevalent recently, maybe. And maybe that's why this whole emphasis on civility is coming up. And maybe I should put this question to both of you. Have you had any experience, and do you think that some of this is cultural? That, in California especially, we deal with, multiple different cultures, and each culture deals differently with this concept of the legal system, hiring a lawyer, then getting involved in a legal dispute. What do you guys think of that?
Amanda, go ahead.
I mean, I think cultural considerations always have to be given their due, right? And I appreciate that from the plaintiff's side, right? If there is a cultural expectation, that you need to have the mediation process to feel really good, like you got the last dollar out of it. I think that sending that information over to defense counsel so they can pass it on to the insurance carrier is really helpful up front to know, right? Because everybody needs a different process when it comes to mediation, right? We all come in with different expectations, different goals. And so to know what that day is going to look like in advance, if there are cultural considerations, is helpful. I think a lot of it, though, and the increase that we've seen, that I've seen in my practice, is the same increase that all of us are seeing in our day-to-day lives. Tensions across the globe, across the country, they're rising. People's temperatures are up. People feel like live wires. And so I think that what a lot of us have to do is re-engage with this idea that it doesn't have to be this way, right? If we as a profession collectively commit to, in dealing with one another, we're going to promote each other, we're going to lift each other up, right? And we're going to treat each other with respect, and that will garner respect back on us. That's going to take that temperature down from other things you might be feeling in other aspects of your life that are out of your control. Civility is something you can control. And when we were talking in preparation for this, Greg sort of had this comment that reminded me of something I did in practice too. When you're ready to write that fiery email, right? Greg said you'd write it, you'd save it in drafts, you'd wait till tomorrow morning, you come back and you read it. And 9 times out of 10, you're not sending that email, right? That I think thinking about civility is such a good time to step back and to reflect on our own selves, because we can't control uncivil actions of other attorneys. And I'm sorry to everybody. I don't know if it's my hand motions that make those thumbs up come, but they keep popping up. I hope it's not too distracting. So that would be my sort of answer, is that we are able to control ourselves, not others, right? And that this is a reflection of what we're capable of doing in our own lives. Greg, you probably have something very brilliant to add.
I don't know about brilliant, but I will say that what I said to Amanda and Steve is I get that nasty email, I get that nasty call, and I immediately, especially if it's an email, I will erase the name of the other attorney because I don't want to accidentally hit send and be uncivil, right? I put my name there though. I put my name where their name would be, and I'm doing the same. It looks like I'm getting some thumbs up too, man.
Yeah.
I put my name there, and then I write the email that I really want to write when I'm mad. And I write it, and it has a lot of expletives. It has a lot of things that I know that I shouldn't be sending. And when I'm done with it, I double check and make sure there's no one on it but me. And I actually hit send. I want to send it to myself because I find myself feeling like, now it's done. I've actually responded, right? And then I let it sit for 24 hours. I get a good night's sleep most of the time because I hit send. When I didn't hit send, I wasn't sleeping as well. But I hit send and I feel like it's done. And then the next morning I'll wake up and sometime during the day, I'm like, all right, now it's time to go revisit it. And I actually reread it and I laugh to myself. Like, there's just no way I should have ever even said some of this stuff, much less, sent it. And I'll just, and then I just write what I should write. I was taught as a very young lawyer by one of my mentors that everything I'm going to write, I have to write like I know will be put as an exhibit for a judge. I was just going to and if I write it that way, I'm going to come across as the reasonable one. And 98% of the time, if I write a reasonable email, a judge is going to look at me and think, this guy's reasonable, right? I mean, it seems like what he's asking for is not out of the norm. It's not like crazy. And if you do that, you're going to win more times than not. I don't say 98%, but a lot more than 50%. Stephen, answer to your question. I don't know that I buy cultural. I think we all come into this profession and we think, we're supposed to be bulldogs and fighting. And I think that's sort of an image we have. We're coming in. I can't tell you the amount of times that people ask me, what's it like being a lawyer and being in a fight all the time? And I say, I'm almost never in a fight. Like I rarely get in a fight. I see your point. That's a really good point. I don't think it's going to beat me, but I see your point, right? Yeah. Maybe a jury agrees with you. I don't know. Right. And I will tell you, and Amanda, I think you'll agree with this. It's more intimidating when someone doesn't take that bait. And it's like, look, man, you could beat me. I had a lawyer who I came in on a case to try a case. He's like, you're never going to settle this case. Scorched earth, screw you, blah, blah, blah. All right, I'll see a trial. Never brought up mediation, never brought up settlement, did everything I could professionally. He did everything he could. He'd stand up and point at me and try and get under my skin. And I'd just be like, look, you're right, but I guess the jury will decide. I mean, that was always my answer. I guess we'll just see a jury will decide. And guess what? He didn't want to try that case against me. And he ended up settling with for a lot of money because he got intimidated by my civility, frankly.
Right. So I think one of the things that comes to my mind is that, I mean, is it civility, the civility that we're talking about, is it just about manners or is it also about the way you handle the litigation? I think it's an all-encompassing kind of a thing. Like, in discovery, don't abuse discovery. Or, when there is a reasonable request for an extension, don't be a jerk about it. Or maybe even a trial continues or whatever it is, and what I'm hearing from, you guys and a lot of other good attorneys is there's no point in doing these silly fights and being a jerk. You can, if you're very confident about yourself and your case, there's no reason, just like you said, Greg, if you've got a good case, you might as well just go forward and be very civil about it, be very courteous about it, and just say, I guess we just have to agree that we disagree about the value of the case, and we'll just let those 12 people in the box decide that.
Yeah, I think I have an example of what I saw as uncivil conduct in my practice when I was out litigating. Luckily, I have a dream job now. I don't quite have to get into these battles as much as I used to. But it was a contentious case. Both sides had relatively good arguments, right, and bad arguments. And there'd been a ton of discovery disputes, and I had both of my grandmothers pass away within 2 days of each other. I let opposing counsel know because this case was taking up like 60% of my time. I'm going to be here for the funerals. Please do not do anything while I'm gone. I'm only going to be gone for a week. The trial date is still 4 months away. No motions, right? Please. and I got 2 ex-parte notices while I was gone, right?
Oh my goodness.
Now, how do you think it went for that lawyer?
Yeah.
I had a lot of credibility with that judge, and both of them were denied, but I had to shuffle. I had to get people from my office to cover while I should be focusing on mourning. How good do you think that exhibit looked for that attorney when it was very, obvious that he was trying to take advantage of a situation? And I think about civility, it's not just manners, it's about being a human being. How do you want to be treated? Right? Because we are all, yes, this is a system that we're operating in. And yes, there are rules. We got to stick to the rules, and we want to get the best result for our client, but not at the sacrifice of humanity. And I think if we all think of it from that perspective, what are our values? What are our visions? How do we want this practice to look? It'll make for a better, more civil practice.
Look, I do everything from the perspective of trial, right?
Mhm.
If imagine, Amanda, going to trial on that case, and you're in front of the judge that realizes that they tried to take advantage of you and your client when you were going through a heartbreaking loss, right?
Right.
A judge is going to hold that against them. And any close ruling is going to go against that individual based upon their conduct. So,
and that is how the case played out. You're absolutely right.
Right. I mean, if you go stand in front of a judge, I think we all talked about this last week. Look, I'm from the Inland Empire. So we don't have a lot of judges in Riverside, San Bernardino, and they all know me. And they all know for 35 years, when I say something, I mean it. So if I say yes, I don't need to write a confirming letter. I do, but I don't need to, because the judges have known me for 35 years. And every single time I show up, I write the letter the way I'm supposed to, not the one that I sent to myself, right? I do all that I'm supposed to do. And so when I go in front of a judge and it's me versus someone else, almost 100% of the time, they know they can trust my word. Right? They know I'm not trying to take advantage. They know I'm not going to try and take advantage of Amanda at that time. So, at the end of the day, and I practice up and down the state, I try cases up and down the state. And when my letters, even if I go in someone else's home court, and yes, it starts off as a hometown, they're going to get the advantage because I'm in Oakland, Alameda, and then, who are you? And we can't trust you. But the more that I'm there, right, the more that they see that I'm professional, that they know that I'm in a BOTA, usually they look me up. And the more that all that stuff, they understand at the end. By the time I go to trial, I'm on equal footing, even if it's their favorite person from hometown, right? Because they understand that I'm doing my job, I'm doing it professional, and I'm not being a jerk. Steve, in answer to your original question quickly, a lot of lawyers in my firm, I have a firm of like 13 lawyers. They always say to me, they agree to everything. And I'm like, look, you don't have to agree to everything, right? There are rules to the game. Back to sports. There are rules to this game. You don't have to agree to an extension. But why wouldn't you, right? I mean, unless it hurts your client, in which case it's a totally different thing. I have told numerous opposing counsel, look, I've given you 10 things, but that's for trial now, right? And it would be malpractice for me to give you an 11th, because I need the discovery to go to trial. So as much as I want to say yes again, I just can't. And it's very easy to use the rules professionally and just say, look, this is now detrimental to my client. I've given it to you before. I can't do it now. But it's very intimidating for them if you're very professional and you know the rules and you use the rules in a way that's professional and noble and say, I'd love to give it to you. I just can't. And here's why.
Right. So I think what I also heard you saying is really the issue of reputation. Your reputation is important as an attorney, and that, whether you've been kind and courteous and nice to other people in your practice will eventually get to the judges and the courts, and they will know what kind of an attorney you are. And so that's, I think, what you brought up is really important. I think it's extremely important whether, I have a good reputation or I don't. It's not just winning that one case at, no matter what expense. I think that it's important to keep in mind that that's just one case. You need to move on, and eventually you're going to have multiple cases, perhaps even with the same opposing counsel, the same judge, and so on and so forth. So your reputation really becomes a very, very, valuable asset that you have as an attorney.
And I think
go ahead, man.
Oh, sorry.
No, go ahead.
I think it's important to note, too, that a reputation takes decades to build, right? And do you know how long it takes to destroy a reputation? No. Minutes. Right. One bad decision, one bad press article, it can be destroyed so easily. You lose credibility with the bench, with the bar, with your colleagues, your friends, so it's just not worth it. For all that work you put into building a practice, I don't want to be remembered for my worst decision. I want to be remembered for the good I did, right? And so I just wanted to point that out.
And I would say, I would say, sorry, Steve, I would say I get calls from opposing counsel who I've not faced before going, look, I looked into you. I know I can trust you. You have a good reputation. Mm-hmm. And, ultimately, it as big as the legal profession is, it's pretty small. I can pick up the phone and call someone and find out about Amanda. I just called someone up in San Fernando. Hey, what can you tell me about Amanda? Right? It's not that hard. Right. And, and they do the same with me. And the reality is it's just so much easier to practice and so much better on your life if you're just pleasant about it, right? I mean, I just really do believe that.
It's better for your own personal mental health to operate in this way.
Well, and the biggest compliment I ever get is I get referrals from opposing counsel, defense counsel, and judges all the time. Like, you were really effective. Compliment. Huge, yeah. You were really effective, and I've never been a jerk, right? So, take that for what it's worth. And when I get it from them, I almost always take them, and they're usually bigger as well. So it's not so bad. It's good for your profession.
Yeah, it's just but unfortunately, it's out there. I remember maybe the first or second year of my practice, I was handling a very contentious case, and every letter that came from the opposing counsel was a nasty gram. Mm-hmm. I'm not that kind of a person, and I finally got tired, and I wrote him back, and I said, I don't think we need to, be nasty with each other dealing with this case. It may be that our clients didn't like each other, and that's why they're in this legal dispute, but we have a work to do, and we can do this, kindly and nicely, and just get it done. He writes me back and he says, if you can't handle the fire, stay out of the kitchen.
That's unfortunate.
That's ridiculous.
I was floored. I was like, okay, I guess I can't work with this guy.
Yeah. Well, and sometimes when someone presents with uncivil conduct, again, that's, you have the rules. You can play with the rule book. If you need to bring it to the court's attention, absolutely do so, especially if it's harming your client. But in that situation, the only thing we control is our own reaction. That's it.
Yeah. It's funny. That reminds me of a story, Steve. Years and years ago, there was a guy in the Inland Empire who would never grant any. Like, my job is to make your job hard. That was his perspective. So I had a case, I'll never forget it. My client was, I think it was at Albertsons, and she bought some wood for the weekend. She was up in the mountains, and, a attendant took it out and dropped it on her foot and broke her foot. And, she lived up in like San Fernando, up by UMed, I believe. And opposing counsel, I call opposing counsel and say, look, my client's like older. She's difficult time reading. I'm going to have to drive. This is before Zoom, by the way. That's how old I am. I'm going to have to drive up there and meet with her to kind of go through these answers. It's just going to be difficult, right? Can I get a 2-week extension? No, right? My first extension, like 4 interrogatories. No. Okay. So I drove up there. I made time. I drove up there. I did it. I came back. Well, guess what? A month later, he has his assistant call me and say, can I have an extension? And I said, you know what? You tell him, I won't say his name. I think he's passed, but I don't know. You tell him that I am more than willing to grant him this extension. I mean, I look forward to it, but he has to call me and ask me himself personally, because I'm not going to take it from you.
Good call.
Once he calls me and says, Greg, can I have an extension? I will give him the extension, because that's the way this profession is supposed to be. He never called me, but he also never, ever didn't give me an extension from that day forward. Because I literally just said, if he calls me, I'll give it to him.
Mm-hmm. And I think that's an example of playing within the rule book, right? Controlling your own reaction and ultimately getting what you want without having to go into court and, bring it to everybody's attention and make it some all-out war. That's a great example.
Well, yeah, it's knowing the rule book. It's also what we were saying earlier, Amanda, which is when we sat outside the courtroom and we had to see each other, it's a lot harder to be a jerk.
Yes.
Right. And for him to actually have to pick up the phone, not send me a letter, because I know anyone could write that letter, pick up the phone and call me himself and say that, that's a tougher pill for him to swallow. And that is. Okay. Yeah.
It is.
So
I guess it's the concept of what goes around comes around.
Yeah, exactly.
It does.
If you're not giving extensions to them, you're ultimately going to need something someday.
Exactly.
Give it to you?
Exactly. Yeah. So that's amazing. So I think what I'm kind of trying to create a summary of what civility really is all about. And I think what I'm hearing is the idea of honor as an attorney, integrity, working within the rules. But, if you have to be a solid, zealous advocate, so be it. But, play by the rules and be kind, be nice. Dignity, courage, courtesy, all of these are the elements that I'm kind of seeing in this whole concept of civility. So what I'm wondering about is, I go back to my very first question is, why is it that even we're talking about this now? Why is civility all of a sudden apparently in short supply or something that everybody's talking about it? Why is that?
I think it goes back to, we're becoming more and more polarized in our lives. It's not just in law, it's in our lives, right? I mean, I actually sat through an MCLE at a BOTA years ago, and someone was talking about, when you search for something on Google, right? If I search for dairy products, right? When I hit send, before it even populates to me, it is sent to like 50 companies, right?
Yeah.
And all of a sudden, we've all seen this. And all of a sudden, next I'm on I'm on a football website. All of a sudden, I'm seeing like dairy products popping up. That happens on everything. That happens when you search the news. So when I'm reading an article about incivility in court and this, it understands my leaning, and it goes further left or further right, depending upon the article. And the internet and all that, we're starting to become, as a society, uncivil. And I think that that's scary, right? I mean, judges themselves are under attack. They're afraid for their own safety by making a ruling. That has nothing to do with the courts. That has to do with just civility. Amanda, I didn't mean to hog that. Go ahead.
No. And I think it gets back to, that has to do with the state of humanity, right? And how we treat one another. And I think that, you're right, that the algorithms play a big part, that once you sort of get in this vortex of reinforcing your own understanding of how you should operate, right? Should those articles be about, tactics that worked, that were really aggressive, and you get in that algorithm, right? And then you kind of get it in your head that I need to really stand up more. I need to give less and take more. It's equally able to go in the other direction. And I think that has happened to some people. I think, and I do think that we're at a real crossroads where we can come together as a profession and help to stop the train from making it further unraveled, because it shouldn't be that way. None of us should fear for our lives or our safety for being advocates for other people, right? That's not how the system works. That's not what it's meant to be. And I would love that we're having a completely different conversation in 5 to 10 years, hopefully.
Yeah.
Right. So, Amanda, maybe I should ask you, being an ethics attorney, I think there's a new rule 8.4.2 being proposed that talks about this whole idea of, not being unprofessional and, all of that stuff, essentially being incivil or uncivil.
Yeah.
So where do you think that goes as far as discipline or some kind of a price to be paid for not being civil, not observing civility within your profession?
I think that certainly with these proposed rule changes, the state bar is becoming more and more interested in making this a rule of professional conduct that we're all going to follow, right? Because if it's not, and there isn't an enforcement mechanism, then incivility or civility is as good as the paper it's written on, right? So I think that what you're seeing is that there are going to be potential enforcement actions. And that gets back also to the new snitch rule that we have, right? Where we have to be reporting on certain fraudulent conduct of our opponents or other lawyers we encounter. If we know that they're lying to the tribunal, we have a duty to report them. I think that this kind of goes part and parcel with that, right? That the bar wants attorneys to be more active in holding one another accountable for these rules, right? Because the state bar can't do it all. They can't bring all these disciplinary charges, right? But if you are communicating with your opponent and there's the threat of the snitch rule, which I certainly don't want attorneys using as a sword, right? I don't think that we need to be reporting our opposing counsel for every little thing. That is not what I'm advocating for. But I think that if we know that there is the potential exposure to our license by acting in civil, that's a different thing, right? That's more of it. If you're not incentivized to do it because it's good for humanity, hopefully you'll be incentivized to do it because of your bottom line, because you can't operate without that law license. And so I think that's part of what we're seeing with the rule changes. I do like the way that the new rule, the language of it, we were kind of saying, what is incivility, right? And when I was preparing for this, we sort of talked about that old constitutional adage of, there was a question for the Supreme Court, what is pornography, right? And the answer is, it when you see it. And I think that incivility is very much the same way, right? That example with my grandmother's, that's a pretty easy, when I describe you to it, you all go, oh, that's horrible, right? So the way that 8.4.2 is defining it says defines incivility as significantly unprofessional conduct that's abusive or harassing and determined on the basis of the facts and circumstances surrounding the conduct, right? We got to look at it as a whole. And was there effective advocacy going on there? And maybe it could have just been worded better. Or does this go to the level of harassment where it's personal attacks, right, on your opponent? And so I think that the rules are getting at the heart of, we need more enforcement mechanisms, because doing it for the good of the profession may not be enough of a motivating factor for everyone.
But I think this goes back to what we were saying earlier, Amanda and Steve, which is, if you're the professional one, it's better for your clients. You're going to get more favorable rulings with the judge. You're going to live a healthier lifestyle. Having been Calabota president, it also can bar you from entry into a lot of organizations, right?
Right.
ABOTA years ago, under our president at the time was Doug DeGrave, defense counsel. I've litigated against Doug, and I've had dinner with Doug. We get along really well. That's the way it's supposed to be, because you don't get into ABOTA. I got 150 trials, but I'm a jerk in one of them. I might not get into ABOTA because that one attorney will say, look, I've tried that case against Rizio and I just didn't think he was ethical. I didn't think he was honest. I thought he was a jerk. It was an unpleasant experience. And you might not get in. So, at the end of the day, there's a lot of reasons why you want to practice civilly, not just because there's the snitch rule. And I'm with you, Amanda. I was always, I was with CAOC when that was all being discussed, and I was the president, and I didn't really love it because too many people are going to pick up the phone and say, that guy was really jerking. And you're not, right?
And that's not what it's really for, if you read the context of the rule. But
but there's a lot of people out there who are going to use it as a weapon, and that goes exactly against what we're talking about, right? Be civil, be honest. If someone reports me for whatever, and when I've never in my mind been uncivil to somebody, and I have to now defend myself, and I find out who did that, I'll still be civil to them, but they're not getting any extensions, much like that guy in the Inland Empire, right?
That's funny. And that's a pretty good point. And that's, this whole idea of maybe being, cut out of some organizations that you really care about and you want to be a member of, or what, Amanda was talking about. There's also these cases that have been coming down where the attorney has been hit on the, as you said, Amanda, the bottom line, where the awards have been cut by the judge, by the court, and the courts of appeal have upheld it, saying, the way you were being so uncivil in this litigation, you don't deserve to these fees, and there've been some serious cutbacks on their fees. So some of those cases we've put in the written material, but it's there. In fact, there was a sentence in one of the statement out of one of these cases that really struck me. It said, and this is the Massimo Corporation versus the Vanderpool Law Firm. and it says, excellent lawyers are civil.
Mm-hmm.
I thought that was just such a, succinct, culmination of what we're all trying to say, and that's also goes back to another question that I wanted to bring up, and I totally forgot. And that is when we were talking about why is it that, the attorneys think they have to be bulldogs. And that's the concept of, is it that you are perceived as a weak attorney if you're being too nice to the other side? What do you think of that?
Well, before we get there, let me say one thing. I just finished a case in San Bernardino. The opposing counsel was nice. The defendant was not, right? Mm-hmm. So those cases you just spoke about where they would cut someone's fee, I won the trial, right? And so now I get to go in and say, the other side made me work that much harder. I deserve a higher fee. So it's also bad for your client, because if you lose, you might have to pay even more. And you don't want an opinion that says your client paid more because you or your client was unprofessional. You have to have control of your clients as well. So I think that's a poison pill that goes both ways, right?
Of course.
Mm-hmm.
I'm sorry, we were talking about being a weak attorney. Are you seeing weak if you're professional? Amanda, I'll let you start on that one because I just was talking. So
no, and I think the answer is pretty simple. The answer is no. I don't think that speaking to people on the level you wanted to be spoken to is a bad thing, that it can be seen as weakness, right? I want to impress you with my strategy, my analysis, my computation of damages, and my presentation, right? It is my job to be a good lawyer and to convince the jury that my side of the story is the correct one, right? And I'm not going to get there by lying, cheating, stealing, because the jury's going to see right through it. Opposing counsel is going to see right through it. The judge is going to see right through it. I don't think that giving in makes you a weak attorney. I think it strengthens your case. And this gets back to what Greg said. If your opposing counsel likes you, they don't want to try a case against you because they're worried the jury's going to like you and that they're going to be eating out of your hand.
Well,
so
guess what? Yeah. Sorry, man. Guess what?
I'm done. I'm just rambling.
Again, I have learned over my 35 years plus probably now experience that jurors want to see professionalism, right? That the main goal in a jury trial is to gain their trust and credibility. And if you're writing things in discovery and that make you look like a jerk, I'll pull that up, right? I'll put your client on the stand. I'll make them say under penalty of perjury. And if the answer is jerky, they're going to look bad. And I'm going to be super nice and credible. I mean, I tried a case in Orange County many years ago against a gentleman, a defense counsel, and we got along fabulously, but he had just had knee surgery. The jury watched me say, hey, do you need me to take this down for you? You need me to help you do this? And, at the end of the day, I didn't do as well in that case as I wanted, but the jurors all commented about, how much they appreciated the process and how much they really liked that we got along. And, you're going to lose a lot of credibility, everyone, again, it all comes back to trial. Everything I do is from the perspective of trial. I want that judge to know I'm the professional one. I'm the one who's persuasive. I'm the one who's done my job. And I've been nice to the other side because I'm going to get better rulings. And I think jurors are going to give you better results if you're seen that way as well.
And I think, jurors seeing civil conduct, it makes them more comfortable. And the flip side of that coin is that uncivil conduct, it makes me feel uncomfortable. If I'm sitting there, right, because I sit in this claims processing role right now. And if I sort of see my defense counsel and my plaintiff's counsel really going at it, it starts to make me uncomfortable, not because I don't understand the arguments and what we're trying to say, but just because it seems so unnecessary, right? We're not going to get anywhere by screaming at each other. And I think jurors react the same way. They don't want to see people yelling at each other in a courtroom.
Yeah. And by the way, there's a lot of people, I videotape every single deposition. So if you're acting like a jerk, somehow a jury's probably going to see that, right?
That's
and a lot of times jurors want to know, why am I here? Why hasn't this gotten figured out, right? And that depo video might give them a key idea of why they're there.
Why? Exactly. Well, and as a mediator, I guess these days, for me, when I was talking about the cultural issues or just being a bulldog and all of that, sometimes to me, it appears as if it's just a show for the clients. They're trying to show that they're really fighting for the client, and there's no way that I'll take that, Steve. It better be this much, or it better be this kind of a result before I can say yes or to this or whatever. So, my job becomes like babysitting a little bit. I have to pull them out and say, okay, tell me what's going on. And sometimes they tell me, they say, I've got the client from hell. Help me out. Oh, okay. Now I understand what's going on. So, that's...
Steve, hold on a second. Amanda and I have been doing all the talking. You're not getting out of this that easily. As a mediator, when someone comes in and they're putting on that show and they're acting that way, I mean, doesn't that make it, because if they're doing it for you, they've probably also done it to the other side. From a mediator's perspective, how much harder is it for you to settle a case when someone's been a jerk?
It makes it difficult. That's for sure. That's why, at pre-mediation phone calls, one of my questions is, how do you guys get along? What's your relationship? Thankfully, for the most part, I hear that we're fine. We get along. It's just that, he or she doesn't agree with what I'm saying, or they don't buy our theory of this and that, or whatever. So, yeah, for sure. And if, especially if it's happening, in front of the client, then it becomes so much harder to convince the client that, hey, look, what the other side is saying makes sense. Or whatever they're offering, it's not so bad. Because now they're seeing this, this gladiator that's fighting for them, and they're rooting for that gladiator and saying, yeah, go for it, get it all for me, or do this and that for me. So it makes it very difficult. So yeah, totally agree with what you brought up, and thanks for bringing it up. It's not easy.
Well, it goes back to what we've all been saying, right? Which is, it's easier to get, something with honey than vinegar. And if you want to settle your case, if you want to live a pleasant life, I just think, live by the golden rule. You can't argue it to a jury, but live it. Make your life better.
Right. That's for sure. I remember that reminds me, I had a very, very nasty business fraud case that I was trying. This is about maybe 20 years ago. And thankfully, it wasn't a jury trial, because it was I don't want to say it, but, ding, ding show, it was that kind of a trial. Nasty allegations and accusations, both sides. And it was just really bad. So, and thankfully, the other side ended up, who was the defendant was not an attorney. His wife was, and the wife was representing him. And she got smart and brought a trial attorney into the picture to create a little bit of separation, which was very helpful, because then with that other attorney, we got along. We actually joked and laughed and whatever. Still a nasty case. But speaking of, lying, cheating, and stealing, we had subpoenaed certain business records from a third party, and they were very critical to one issue of the case. And so they got to use those records first. And it took an entire day to go through those records with certain witnesses and so on and so forth. My turn was the next day. So I come into the courtroom the next day. I want to use it with my witnesses, and those records are gone. And we're like, oh, wait a minute. Where are these records? A whole box of subpoenaed records are gone. And so we brought it up to the judge's attention, and this attorney who was brought in was, I think, honest enough to say, look, I don't know what happened. I have no idea. I had nothing to do with it. And so the judge said, okay, I'm gonna stop the trial right now. I'm gonna send both of you to the parking lot. You're going to Mr. So-and-so's, the other attorney's named car, to check his car and check the trunk. Maybe by mistake, he took a box that contained those records. And I was like, wow. I was dumb. We did. We actually walked, and I'm like, hey, buddy, did you take it? And he's like, no, they're not in my car. What are you talking about? So we came back, and I said, you know what, Your Honor, I have no idea what happened to these records. And speaking of creating a reputation and who you are before the judges, several things that had happened in this trial that the judge really got it, that I meant what I said. and I could stand behind it. And I wasn't really trying to lie, cheat, steal, or anything. So the judge, after he heard that we couldn't find the records, he said, Mr. Sepassi, why don't you make an offer of proof of what you would have tried to show with those records? And I did, and the judge took that. And the case really went south. They lost the case big time. We actually ended up going for the punitive phase. And so, the case really went for me because I was just really straightforward with everything. Even if I was making a mistake, I would tell the judge. I was like, oh, I'm sorry, Your Honor, this was a mistake. I shouldn't have brought this up. Or sorry, this happened and that happened. So I think being honest, being straight, being honorable, being courteous, all of that pays off in multiple ways, in trial, in litigation, in mediations, in this whole concept of being in this legal system. I think that it should be the foundation of everything we do. So that's how I look at it.
And what you just said is powerful, Steve, because acknowledging mistakes, no one's perfect. Right? I can't tell you the amount of times I've heard other lawyers in front of a judge, well, Your Honor, my paralegal or my receptionist, or I don't know. I almost always fall on the sword. Look, Your Honor, I don't know what happened.
The buck stops with you, for sure.
Right? It's on me. I'm the lawyer. It's on me. And let me say this, and Amanda, I think you can confirm this from a plaintiff and then to a defense. I get brought in on cases from people who are jerks all the time to try it, right? I do. And it's so much harder for me to get a fair settlement prior to trial. It almost forces me to try cases because even though the attorney likes me, the adjuster just can't get that bad taste out of their mouth as to how they've been treated for 3 or 4 years to then say, you know what, Rizio's a better lawyer. We might want to get more money for that.
I can kind of tell you a little bit of the logic behind that, and that might be our last point of discussion because I see we're running out of time. But it's that, say you go to a mediation with the jerk attorney and they're not coming off of their unreasonably inflated demand that we know no jury's ever going to give them. It's ridiculous, right? And they're not willing to negotiate. Then the carrier goes and they spend another $100,000 in defense fees getting the discovery that probably should have been turned over in the first place, right? Or, then from their perspective, they're going, wait, you want me to get reasonable when I had to spend all this money unnecessarily because of your actions, right? That's a very hard pill for people to swallow from the defense perspective. And I think it's a correct sentiment. Sometimes we have to let go of that if we're going to get the case settled. But I understand the sentiment behind it.
That's a great point. That's a great point. Okay, Anna is here to...
Yes, thank you guys so much. This was such a great discussion and very dynamic. So thank you all for being here. I thought we could just answer like 1 or 2 questions before we sign off here. So one that we had from the audience was, how do you suggest an attorney handle another attorney who refuses to be civil?
I'd say take the high road. I mean, I've had so many lawyers literally. I have said this in things before. Like, hey, I have said, hey, I'm sorry if I did something that you misinterpreted because that was not my intent. Now, I have been told, and Amanda, you're going to have to tell, some women lawyers have told me that women lawyers have been taught not to apologize because it might be seen as weakness. And I'm not a woman lawyer, and I don't know if that's correct or not. But I've always taken the high road and just said, look, I'm sorry. I think we've gotten on the wrong foot here. I think you've misunderstood something I've done. Amanda?
Yeah, and I think that there is some truth to women lawyers are taught that, although I wonder if that's changing as more of us, we're about 50% of the profession now. So I think some of the older female litigant roles that they might have told me when I was younger might be kind of going out of style. But I think that the best thing to do is exactly what Greg said, disarm them, right? Take away their power of being mad by disarming them. Wow, it sounds like you're really upset. And to the extent any of my actions caused that, that's distressing to me. I don't like that. I don't like that in my profession. Take the anger back from them, right? Because when you get that kind of communication from your counsel, it's very hard to stay mad. Very hard.
So I'll also say something here that, as a mediator, that sometimes it falls on me to, go back to the other room and say, look, I don't think he or she meant to be, nasty or uncivil with you. It's just, there was a situation or whatever. he has or she has a lot of respect for you, and so on and so forth. So I do a lot of sugarcoating sometimes if I see that kind of a relationship dynamics are there. So anyway, maybe another question, Anna. Do we have time?
It is 1 p.m., so I want to be respectful of people's time. So I think that's all the time we have for today. But thank you, everyone, for joining us. This was such a lovely discussion.
ADR Services, Inc. has been your unwavering partner in alternative dispute resolution. But as the world changed, so did we. From virtual and hybrid hearings to our ongoing on-demand CLE program, ADR Services, Inc. continues to keep resolution and legal education at the forefront, woman-owned and operated from the start. There is someone for every situation. We are ADR Services, Inc.